All right. Good morning and welcome to this meeting on the Committee on the Revision of the Penal Code, which is now in session. I am Mike Romano, Committee Chair. Thank you for joining us, everybody in the committee, staff, members of the public. I want to begin with an alphabetical roll of committee members and beginning with our newest and Assembly Member El Hawawi.
Yes, I'm here.
Can you correct me on how to pronounce your last name appropriately?
Al Hawari.
El Hawari, is that right?
Yes,
El
yes, that's
Hawari.
perfect.
Excuse
Thank
me.
you. No
Judge
problem.
Espinoza.
I'm present.
Mary Kennedy.
Present.
Professor Ochin. Okay, she's not with us. Professor Rummel
Here, present.
and Senator Weiner. He's also not with us right now, but we have enough to get going, so we're gonna plow ahead. This is our first meeting of the year. We have four more planned. Today we'll be discussing pretrial diversion and record relief. To explore these topics, we'll have three presentations from invited speakers and staff presentation. We'll also hear from staff about pending bills related to committee recommendations, crime data, and a few other updates. We'll conclude as always with public comment. As we begin, a few reminders about Bagley Keene. First, please note that members of the public can watch and participate in this meeting in the first floor conference room at 925 L Street in Sacramento. Thank you once again, Megan, for being present there for us. Second, a reminder to committee members, the law requires that committee members be visibly appear on camera during the meetings unless there are tough technical difficulties or screen is being shared. If you do have technical difficulties, please let us know and we'll try our best to handle it. All right. I also wanted to, before we get started, to welcome Assembly Member El Hawari. El Hawari. It's going to take me a second. I really
Yes,
apologize. Um,
thank you
Assembly
so much.
Member El Hawari was elected to the legislature in 2024 and represents Exposition Park in Los Angeles and South Los Angeles and downtown LA. She's already been a great leader in criminal justice issues in the legislature, and we're very excited to have you aboard. So thank you for joining us.
To being part of the Penal Code Revision Commission.
Thank you. We've been doing this for quite a while, and please do not hesitate to speak up about anything that we're doing, either substantively or procedurally. We want to be this as collaborative as possible. So we're all friendly here. All
Sounds
right.
good. Thanks.
So this is our first meeting of 2026, and I wanted to take a moment to recognize the progress that California has made in improving its justice system. As we'll hear later on in more detail, California has really had remarkable results. We've achieved near record low crime rates across the state. At the same time, we're continuing a trend to incarcerate fewer and fewer people. The prison population has been cut nearly in half since its peak in 2006. Our goal when we started this committee was to research and advance policies that improve public safety and reduce incarceration at the same time, and I think we've done exactly that. Today, we'll be discussing two important policy areas that have helped accomplish these goals: diversion and record relief. As with many areas of criminal justice, California in many ways leads the country in these areas. I also want to take a quick note that we're experimenting with a slightly different format of meetings this year, which we hope will facilitate even more discussion between committee members and subject matter experts and speed our proceedings along. Okay, with that said, our first focus will be pretrial diversion programs, which allow a case to be dismissed if the defendant completes, excuse me, if a defendant completes conditions decided by a judge, and they apply in a wide range of circumstances in California, and existing research suggests that they can make long-term improvements to public safety. At the same time, these important programs often misunderstood, and I look forward to learning more as we discuss them today. Similarly, record relief laws, which limit public access to many criminal records, are extremely important, but also extremely confusing, at least at first glance. Research that we'll hear today from our friends at the California Policy Lab shows that the vast majority of people who are convicted of crimes in California are likely to get automatic record relief, and I look forward to hearing from them as well. With that said, let's get started with our presentations. We'll begin our presentations today hearing from the Legislative Analyst Office about mental health care in California's prisons and a federal judge's recent appointment of a receiver to take over the system. Our presenter from the LAO is Orlando Sanchez Zavala. Am I mispronouncing your name?
Nope, that was perfect.
All right, thank you. And he's here with Drew Soderberg. Good to see you again, Drew. As with all our presenters, we'll have about 5 minutes of slides and then we'll have some time for Q&A. This presentation will help set the stage for why mental health diversion is so important. Mr. Sanchez Zavala, please take us away.
Okay, great. Just give me a second to share my screen. Thank you, committee, for the invitation. And Here I'll be providing this overview, and some of this stems from a report we recently published this past February, and I'll be discussing some of those topics. So, as mentioned, there's about 90,000 people incarcerated in prison, and about nearly 35,000 of those people have a mental health need, and that represents about 2 out of 5 people currently incarcerated. Here we have a graph showing the how the mental health population has changed in recent decades up to the projected levels. In prior decades, this share was like quite small. It's about 10%, 20%, 30%. But overall, the mental health population has been generally increasing. And some of that is likely because the department has gotten better at identifying people with the mental health need. One more recent trend is as the overall prison population has declined, we've also seen declines as we see here. But an interesting kind of thing happening is that the share of people that are incarcerated with the mental health need has continued to increase despite those uh, overall decreases. So this share in discussions with the department, this likely could be because people with a mental health need have longer sentences, or it's more challenging for them to have earned credits either through good behavior that would allow for an earlier release. In the prison system, CDCR or the California Corrections Department and Rehabilitation provides inpatient and outpatient services based on the need, and that's generally provided at most prisons at no cost. And the vast majority of people receive outpatient services. One of the key drivers in this space has been how the state kind of allocates its budget and makes decisions on treatment is driven by a federal court case called the Coleman Court. This was filed in 1990 and alleged that the state prison system has been provided constitutionally inadequate mental health care for the people in prison. And through the process of the litigation, the state was found in violation of the Eighth Amendment against which prohibits cruel and unusual punishment for not providing constitutional levels of mental health care. And some of the violations highlighted in the court case include not having a mechanism for screening people, understaffing, significant delays in treatment, and a deficient medical record system that would allow tracking. And then here's a little bit of a timeline on various court orders that have been come down from this case. But one I want to highlight for you is this 2002 order that requires the state to fill its have a vacancy rate of 10% or less for mental health providers. So this includes various positions, psychologists, psychiatrists, and so it must fill up to 90% of its budgeted positions. And here in this next graph, we see the state has generally struggled to do that and has not done so. The 10% threshold would have been here. And in recent years, that's actually gotten worse in being able to hire, retain, and recruit enough of these positions. And because of that, that likely affects outcomes for this population. Appointments can be delayed or canceled for receiving treatment. So we know about half of the people in 2024 didn't receive their appointment as scheduled, and nearly half didn't receive the minimum number of treatment hours necessary. And when this happens, it could lead to deteriorating mental health and in extreme cases result in self-harm or suicide. And we know in the mortality report that the department releases every year from 2006 to the most recent year available. It's about 19 years of data. Suicide-related deaths have been a top five leading cause of death within the department about 12 times in the over that span of 19 years. And most recently, it was the sixth leading cause of death. Here in this graph, you show what these are total deaths in the department. And some of these are similar to the general population, like cardiovascular disease, cancer, but suicide rates slightly higher. There have been efforts both from the state and the court since this litigation has happened to improve it. Some of it has been monthly reports on key metrics, experts to monitor the CDCR's progress, the appointment of a special master. This is an oversight tool that the court used for a long time. It increases in the mental health budget, staffing ratios to align with the population, built more infrastructure, and the court has even established and fined the state for not meeting these goals. And kind of as of last fall, the federal court case used a tool that's typically reserved as a last resort when the deficiencies haven't been rectified yet, and it established a federal receivership. And its goal is to bring the delivery of mental health care to constitutional level. So it's now in charge and to take control over the delivery of mental health services. And the vacancy rates were, among other deficiencies, were a main contributor to this appointment. So the department now has two active receivers, one on the medical side, which is in the Plata case that's been around since about 2006 or roughly 20 years. And then this one, and to our knowledge, this is unprecedented and it's we're not aware of any correctional system in the country having two active receivers that have such a significant role in this. We did, in that report I mentioned from February, we do highlight some issues for the state to consider. And that includes that the receivership reduces the state control significantly, but it doesn't eliminate. There's still some oversight mechanisms and changes the state can make in order to make progress towards exiting it. This receivership is expected to last 5 to 7 years is the timeline, but as we've seen in the other one, it could extend further. Some of the remaining issues are complex, and to the extent the state can address those. And then costs are likely to increase from the future actions. And addressing vacancies will be key to ending the receivership. This is something the state has long struggled with, and we'll need to rectify that before it can begin to take back control. And that concludes my presentation. I'll stick around for questions. Thank you.
Thank you so much. It- I have a couple things that I want to say, and thank you. This is really helpful and I think that alarming. Um, 40% of the prison population is receiving mental health care. I think that in order to receive this level of care, you have to have a serious mental health diagnosis. Like this isn't just, um, garden variety depression or anxiety. These are, really serious conditions. And I'm just curious, have first of all, the last time I looked at this, my understanding was that the Latino population was significantly undercounted, or that there were significantly fewer Latinos in the mental health delivery system. Is that still the case?
Yeah, we didn't do a close analysis by race, so no, I'm not able to answer that at this moment. But it is a population that within the prison system is highly represented in it, and to the extent the department has still not been able to improve its screening in that, and it's possible that that still remains.
Got it. We can look into that. I have two other questions that I'm going to hand it over to Judge Espinoza. First of all, the mental health population has grown significantly as the overall prison population has decreased, and that's really, I think, alarming, as you've noted. You suggested that this might be due to longer sentences for people with mental illness, the inability to earn credits at the same rate as other people, or perhaps that just more people are being diagnosed, and we've always had this high. To your knowledge, have there been any real studies about which are the drivers, or is this just guesswork, or do we know?
Right. This is, yeah, mostly from kind of what we've seen in both like we know that there's been improvements in screening. So that's like we can't attribute a percentage of how much that would explain it. The graph I showed previously, it's possible we weren't identifying everyone that had a mental health need. We know across the country about a third of people in other correctional facilities are have a mental health need. Yeah, to my awareness, there hasn't been like a root cause analysis of what's kind of driving this, but in discussions with the department, that seems to be their primary reasons why this share of population's increasing.
So they're crediting themselves for doing a better job at diagnosing people.
Yeah, that's one or the court, and then the other one is these people might have longer sentences or it's harder to earn credits.
Understood.
Kind of
Understood.
these three factors that are the main reasons.
Thanks. Judge Espinoza?
Yeah, it's remarkable to me how this analysis of the state prison population mirrors exactly what's happening in the Los Angeles County Jail. And I'm just going to throw some numbers out there and then I'll sit down. Pre-COVID, the daily census at the LA County Jail was between 17,000 and 17,500. These are brick and mortar facilities built for far fewer people. Um, the mental health population at that time was around 30%. The current daily census hovers around 12,000, and that's the result of a lot of effort, a lot of reforms that took place during the COVID epidemic. But the mental health population is up over 40% now. And what's really frightening to me is the disparity, the racial disparities within that population are just awful. And I didn't have a chance to pull those numbers. Last year in the LA County Jail, there were 46 deaths and primarily caused by suicide and drug overdose. So this is what's happening on the state level is clearly what's going on in Los Angeles County. We are also under federal court supervision in a case called the Rutherford case. Um, Today, as we sit here, there are about 3,000 souls who would otherwise be either in jail or prison who are in our community-based care at the Office of Diversion and Reentry. We operate a number of community-based sites, and I could spend hours talking about the services we provide at those sites, but I won't. And over the last 10 years, ODR has removed more than 15,000 people from the jail and place them in community-based care. So there is a solution to these problems. And of course, community-based care is just a fraction of what it costs to care for truly sick people in a carceral setting. It's just remarkably less expensive. So it is a public safety initiative because our recidivism rate is incredibly low, and housing retention is incredibly high. That's all I have to say. Thank you.
Judge Espinoza, you've been beyond a leader in all of this for decades. You've worked miracles, I would say, in Los Angeles for the whole county, but I will just say personally that you've helped so many of our individual clients, like literally save their lives. And I'm incredibly grateful, and we should all be. And you've never ceased in, you know, calling out. And I think that we should continue trying to figure out how to spread successes in LA and develop more reform. This is the hard stuff, and I think that's exactly what our committee is for. So,
Thank you. And there are currently efforts underway, by the way, to restrict mental health diversion in California. There are bills pending um, that are attempting to restrict those who are eligible for this relief, and it's really disheartening.
Assembly Member Hawari.
And the W is like Hawaii, and it kind of rhymes with Ferrari. Hopefully that helps. Not sure.
Al Hawari. I'll get it. I will
Um,
get it. I'll get it. It's your first day.
we'll
I'm
get
so
there.
sorry.
No problem at all. I promise. I have a couple of questions, and I had a third one, but I forgot. So maybe it'll come back up when other folks talk. But the first question is, um, given where things are politically, just for my own knowledge, like in terms of being in the receivership and specifically what happened in 2025, um, is any of that connected to the federal administration kind of and California being on their hit list, like kind of, or is this just like based, no, like nothing related to the fact that we were kind of not in the best, place and relationship? And I don't know if I got cut off because I feel like you guys froze.
Yeah, I
My
think
second question, I didn't fully follow when you. Oh, I did cut off.
We got you.
yeah,
I had one more question, Orlando. Can you hear me? Okay. The
yes.
question is just when you went through the graph, this represents 10%. I didn't follow because it was like at the 25%. I was clear on what you meant when, because I think it was related to the previous slide when you were kind of graph that showed that it should have stayed at a certain percentage. And so, anyway, you can answer the first question.
Okay. Yeah, it's our understanding that the judge that appointed the receivership has been in place for prior to the administration. So this is likely independent of kind of what's happened. The federal administration is our understanding, and this is just the judge in that case like tried other mechanisms to get the state to by setting court orders and fining the state and felt like those weren't being enough and thought that a federal receivership made the most sense at this point where this court case is now. And the second question,
Thanks.
uh, yeah, maybe I can pull the graph up again if that'd be helpful. But I think I highlighted it in that there was about 10% of people in 1997 that had a mental health need. Um, and then in that, at that time, we were still somewhat earlier than we were now in this case. And the prison population was like vastly different than what it is now at that time. So we had so it could have been a mix of factors that roughly about 10% of the prison population. So as one explanation, as the state got better, then it identified more people or whatever kind of other factors might have been happening. Yeah. And then what I wanted to highlight here is that are you able to see my screen? Sorry, maybe I can make this full screen.
Yeah, I can see it. Thanks.
Right. So about 10% of people had a diagnosed mental health need in 1997. And over the decades, that rate increased. And here we were started seeing declines in the overall mental health population, but um, the rate and share of people who have it
Okay.
has gone up, and that's because the overall prison population has gone down faster than this population is
Can you
what
can you go to the I think there's a graph like two
oh,
slides forward.
this one.
That one, yeah.
Oh,
That's the one
okay,
that I
this
guess
one.
I saw
Yeah.
you point and you said this represents about 10% and you were kind of in the middle. And so
Oh,
I
okay.
just didn't fully
Yeah.
understand that part.
So yeah, so these lines to be under the court order and compliant with the court order, these
Oh,
lines
okay, got
should
it, got it,
be
got it.
down here,
Okay, got it.
but the state hasn't been able to fill.
Okay.
So it's had, yeah, in 2024 we had for a 45% vacancy rate in these positions that the court requires to serve this population. And that's,
Okay, thank you.
yeah.
Now it totally makes more sense. I think I was following
Okay.
wrong, but that was really
Okay. Yeah.
I just want to add that should really be a shame for our whole state. When was Coleman originally decided?
I think 1990 is when it
Yeah.
started. You had that in your timeline, right,
Right.
Orlando?
Yeah.
But
19.
and it's something about Hawaii on sort of the Trump question. I think the receiver was appointed by the court was from the Biden administration. So the person who's in charge of our mental health care system is, I would say, definitely not from that world.
Right. She's the head of BOP, right?
I
And
think
before
so.
and before that, she was the head of organ system. Uh, Good morning, Professor Ocha. Good to see you.
Good to see you too. I just really appreciate the presentation and agree that this is horrendous. I wonder about just the built environment and the way that the staffing levels obviously have a significant impact on care, as does as does the general posture of our system toward folks with mental illness. But there are so many studies that show how enclosing people in spaces for significant periods of time causes degradation of their mental illness. And I'm just wondering how our CDCR's policies, right, the things that CDCR can control, it's difficult to recruit folks to work in these spaces who are doctors, nurses, psychiatrists, et cetera. But what CDCR can control is the way that they use the built environment, the way that they use things like administrative segregation, how long they house people, how much time people get, how long people are held in these facilities. And I'm just wondering, is that a part of the conversation about Coleman compliance? Is the way in which the fact that people are held in conditions that are inhumane, exacerbate pre-existing serious mental illnesses? That's number one. That's my first question. Then number two, I just want to encourage the staff to work with the LAO to get more granular data. I'd love to hear more about how people incarcerated in women's prisons, if the data is similar or different in terms of serious mental illness, particularly complex PTSD. I'd also be interested in knowing the racial breakdown of serious mental illness designation and the types of serious mental illness. So I'd be interested in getting a bit more information, and also and back to my first question, what does the Coleman sort of consent decree require of CDCR just in terms of how they manage populations that have serious mental illness in terms of time that they're in cells, administrative segregation, even being housed in state prisons. If we know that state prisons cannot provide adequate mental health for people with serious mental illness, should courts be sending people with serious mental illnesses to California state prisons?
Great. Yeah, I'd happy to follow up with data we have and with your staff and the staff of the committee. Happy to work on that. On the other question, this is something that the receiver is going to have to grapple with on what policies and how that affects the outcomes and treatment of this population, and something that the court has not thought about, and CDCR has been under pressure in this case to make changes that for people to have enough out of self time. You need enough staff to bring them out and recreate. So there are some kind of policies that are geared towards this population to ensure that they don't deteriorate more. Now, to the extent the department's meeting them, that's something that the court has been tracking and is able to um, show in what areas we're compliant and what areas we're not. And I do know recently the department changed its uh, segregated housing or administrative segregation policies. It's not clear to me whether that's a response to this or how that or responses to other efforts, but there have been some changes that the department has been initiating, given some direction from both the legislature, but also some pressure from litigation.
I fear that almost the age of these lawsuits and the age of this crisis. I mean, it's been over 30 years that California's mental health, prison has been one of the most conservative U.S. Supreme Courts ruled that, it's cruel and unusual punishment to the way that we're treating people who are mentally ill who are in state prison system. And I agree that this is just something we should just continue to try to keep the pressure on, continue to learn more, and continue to help be a voice of reform. So I think we're all kind of on the same page here. Um, Orlando, we don't mean to single you out as anybody responsible. Obviously, you're studying this and just
Right.
bring it to our attention. But anyway, unless anybody else has further comments, I mean, we're going to talk a little bit about, I mean, we're going to talk quite a bit about diversion programs, which help somewhat with this issue or try to, but obviously, lots of efforts are needed. Anyone else want to say something before we move on? Tom, any last words? All right. Our next presenter is Stephanie Brooks Holliday. She's a research associate from the department, she's the Associate Research Department Director for Behavioral and Policy Sciences at the RAND Corporation. Her presentation is an evaluation of mental health diversion program in Los Angeles. Ms. Brooks Holliday, take us away, please. Oh, I can't hear you.
How's this?
Much better.
Okay,
Thank
great.
you. Welcome.
Yes, thanks for having me. Let me go ahead and share my screen. All right, can you all see the presentation screen?
We had it a second ago.
I can see it, but if you could expand it so that it's full screen, I think that
Yeah.
would help.
Oh, sure. Let me see if I
It
can.
looked like the full screen version was behind, and there was another,
Oh,
like the
I see.
PowerPoint window was in front.
Let me try this.
Yeah, no worries.
I'm not
Oh,
a
there we
Perfect.
go.
That's
user,
great.
Thank
so
you.
okay, perfect. Thanks for your patience. Okay, so I'm going to talk to you today about Los Angeles County's Rapid Diversion Program, which is a pretrial mental health diversion option. Are you seeing the change of slides with it or no? No. Zoom gets me every time. How's this? Okay, perfect. Okay, so LA County's Rapid Diversion Program leverages Penal Code Section 1001.36, which was passed in 2018, and creates an opportunity for mental health diversion for people whose diagnosis plays a role in the charge that they face. At the time that the statute was passed, there was a requirement to demonstrate the nexus between the mental health condition and the charge. A more recent change to the Penal Code section created a presumption that a nexus exists. That change was happening around the time that I was doing this evaluation. The reason that RDP was started in LA County is because there, as Judge Espinoza said, has been a really critical need for this as an option. However, getting folks through mental health diversion one by one was a very slow process. It could take months to identify a person who's potentially appropriate, find an expert to do an evaluation, have it go before a judge. And so what LA County did with RDP was aim to consolidate and streamline this process within arraignment courts. So basically what happens is an attorney, when they are first meeting with their client, might identify that they would be appropriate for RDP based on their review of the facts of the case or their initial evaluation, factors like that. And they can make a request for referral for RDP. Clinical evaluators are embedded within the arraignment court so that the evaluation can be conducted on the same day if possible. And those evaluations are largely conducted by master's level clinicians. They have created a 4-page standardized report template to summarize the findings of the evaluation. And then based on the results of that, the clinicians and attorneys must both approve the case to move on to the next stage. One thing that RDP does that is not necessarily required by statute, but they found to be really successful is they have this trial period of sorts where potential clients are conditionally released and connected to treatment using the help of a resource navigator. And then they engage in services for a couple of month period while they're being monitored by an assigned case manager in the clinical team. And after that trial period, then the prosecutor is able to review the case to determine if they agree that the potential client is suitable for diversion. Were they able to show that they can adhere to a treatment plan and engage in treatment? And then if so, then that person is diverted. Once diverted, clients must complete 12 months of treatment for a misdemeanor, 24 months for a felony that's established by statute. And during this time, they're in contact with clients weekly through the case manager, and charges are dismissed if they are successful in their treatment. RDP began with misdemeanor cases in just a single courthouse, but at the time I did the evaluation was operating out of 7 courthouses and had expanded to felony charges as well. So we were looking at first who is graduating from RDP or who is being served by RDP. We were able to look at 2022 to 2024 as part of this evaluation. RDP was established a few years before this in 2019, but their data systems were a little rudimentary when they began, so they only had information about people who had graduated for the early years, and it was really important for us to understand the full trajectory of people through the program. So that's why we focused on this 2-year period between 2022 and 2024. So during that time frame, more than 4,300 people were evaluated and 1,200 went on to be approved for diversion. Reflecting the demographics of the LA County Jail, most clients were Hispanic or Latina or Black, although to Judge Espinosa's point, this is not necessarily matching up with the demographics of the jail mental health population, where Black individuals are even more overrepresented than what we see in the RDP population. Most of the people who enter RDP are in temporary or unstable housing situations or unhoused at the time that they enter the program. And at the time we did the evaluation, misdemeanor charges were still more common, but 43% of diverted clients had felony charges. In terms of outcomes of RDP, so we were able to look at the full sample of folks who had graduated from the program from its inception, which was more than 660 people at the time that we did this analysis. And we found that we were interested in the characteristics of people who graduate compared to those who don't. We didn't find differences by demographic factors or by charge type. The only significant difference that we found is that people who were out of custody at the time that they enrolled were more likely to graduate. And we really think that that out of custody indicator is probably a proxy for other types of things, like clinical acuity probably being one of them. Clinical acuity was the one thing that we weren't able to systematically measure and include in our analysis. We were able to look at recidivism among those who had graduated, which we defined as having a new case filed for an offense that occurred after graduation from the program. 91% of the graduates did not have a new case filed. In terms of the time frame, we had some people in our sample who had graduated pretty recently, just 42 days before we pulled the data on recidivism. But for some of the folks, we had 5 years worth of potential time for them to have a new charge filed. And so it depended on the person, but still low rates of new charges being filed. And on average, when people did have a new case filed, the average number of new cases was just about 1. We had 1 or 2 people who were kind of outliers and had several new cases filed, but you can see here, it was more common for people to just have 1 new case. And sometimes people were eligible for diversion again on that new case. Part of what we wanted to learn from the evaluation, though, was what were some of the successes and what were some of the areas for improvement with the RDP model. So some of the key strengths of the program, or things that were identified as what I like to think of as ingredients to success, were first, the rapid timeline. With traditional mental health diversion, just going individual client at a time, we heard it could take 6 months or more to even get a court-appointed clinician to conduct the evaluation. By contrast, the mean time from evaluation to diversion for RDP clients was about 2 months. So it is really speeding up the process. The relationship between attorneys and clinicians is also really essential. By having the clinicians embedded in the arraignment court, they're really able to foster trust. And that's really key when this type of streamlined mental health evaluation is happening to determine eligibility. And case management has been essential. Case management is not required by the diversion statute, only mental health treatment, but the clients see them as a steady touch point and source of support. And then also the case managers communicate regularly with the court, so the court feels more confident in the program and whether or not clients are adhering to their treatment plan. It's not all perfect. There are opportunities for improvement too, especially as the program has expanded and has been able to divert people with more serious charges. Some stakeholders that we talk to have concerns about relying on such a brief evaluation report, just a couple of pages put together by a master's level clinician. And so that was something that was on people's radar. there was a desire to expand, but also to make sure that decisions were still grounded on good evidence. There are also some types of clients who have been more challenging to link to placements, just given limited capacity in the system of care in Los Angeles. So we heard that people who had a mental health diagnosis only versus a substance use disorder diagnosis or a dual diagnosis, those were folks who could be more difficult to find a treatment placement for. You can imagine that's a pretty large proportion of the RDP clients. And the case managers have a heavy, intensive job. And so we did hear that there can be turnover. There were concerns about high caseloads. And so figuring out ways to have that be a sustainable part of the RDP workforce was another potential challenge. And I just wanted to say a couple other things too. In addition to this evaluation that we did for RDP, I had another project where we were able to look at implementation of this penal code section in 9 counties across California in their early stages of implementation to learn more about how they were making this work and what was going well. So a couple of additional takeaways that I thought might be relevant. So RDP, one of its strengths was formalizing a process. And we found that that is the case in other counties too. When they've been able to create a mental health diversion docket or some other subprogram like RDP, that's really helped them to centralize the oversight of diversion cases. One of the aspects of determining eligibility for diversion in the statute requires an assessment of risk of dangerousness in the community if the person is diverted. And one thing that we did here is that it was unusual for a formal risk assessment to be conducted as part of diversion evaluations, and that can sometimes have a chilling effect on prosecutors and judges being willing for folks to be diverted if there's not some way for them to quantify risk. On the other side, defense attorneys and clients are sometimes concerned about the length of supervision, 12 months for a misdemeanor, 24 months for a felony. And so they sometimes found it more desirable to take a plea or to do something like an early disposition court that would not have them under supervision of the court for quite so long. We did hear from some judges that they prefer options occasionally with more legal teeth, so to speak, like mental health courts. They felt like that gave them more peace of mind having people out in the community participating in treatment. And LA County is not the only place to figure out that it's not just mental health services that are needed. Case management, transportation, housing are other important supports that counties have been providing to their diversion clients. And then we just heard that the capacity issues related to treatment availability within the local system of care can make it really challenging to find treatment slots for people, even when they are eligible and suitable for diversion. Another challenge that can come up are insurance issues when people have publicly funded insurance. Let's say they have a case in one county, but they live and their insurance is in another county. That sometimes creates challenges putting together a treatment plan for folks. So I know that that was a little bit rapid fire, but I will stop there and happy to answer any questions that folks may have.
This is super helpful and actually quite promising. I have a couple of questions and then I'll open it up to everybody else. First, the types of crimes that people are charged with in this program, I'm assuming, well, they're about half misdemeanors, half felonies, it looks like. Of the felonies, I'm going to assume that they're relatively low-level felonies and jail sentences rather than prison potentially. Is that correct?
We did not have a breakdown of specific offenses within the RDP population. There are, by statute, some charges that are not eligible for this type of diversion, rape charges, murder charges. But even in LA County, we found that they were having some success diverting fairly serious charges, including things that may have resulted in a prison sentence. And I think there, a lot of that depended on the willingness of the judge in the given courthouse to do so. They also talked about how so often they had to look at the facts of the case because something might look very serious on paper, but then once you look at the facts, it really showed that it was not as serious as it seemed. One of the examples that came up in multiple interviews were Estes robberies, where someone may have been in a store just looking to shoplift and then was confronted by store security and ran into them, hit them, shoved them on their way out. These are a type of case that they were finding more and more success with being able to divert.
And thank you. That's super helpful and makes a lot of sense. The other thing I want to ask is, one of the, just somebody who observes this mostly from the outside, there are lots of different programs and efforts and a lot of good intentions, but sometimes it feels like a patchwork of services that don't necessarily communicate well with each other. So I'm actually going to ask Judge Espinoza, can you explain the relationship, if anything, between RDP and ODR, which is Office of Diversion and Reentry that you were just talking about a minute ago, both in Los Angeles? Can you help us get a sense of the landscape here? Perhaps Stephanie can help as well. I don't know, but Judge, you're on mute. Judge, you're on mute. Judge Espinoza, you're on mute. Oh, you can't hear us. Okay. Anyway, Stephanie, do you know the answer to that?
This was part of what we looked at with our evaluation, and Judge Espinoza, feel free to correct me or like wave your hands if this is incorrect. But one of the differences that we found is that often ODR is working with people who have a much higher clinical acuity and like significant serious mental illness, whereas RDP tends to work with folks who have more low to moderate mental illness. So that's one distinction. Also, ODR, one of the emphases of that program is not just providing mental health treatment, but also connecting people with housing and ultimately permanent supportive housing. That is not something that is necessarily a part of what RDP is offering to folks.
Sorry, I was having trouble with the computer. Can you hear me?
We hear you twice.
Yeah.
Have you logged in twice?
I think so. I don't know why. Tom, can you mute me on one?
All right, let me try this.
So for
I've tried a few things. Let's see.
how about now?
Judge Espinosa, I think you have to turn off the volume on one of them on your end.
Okay. Well, turned on one and not on the other. I'm gonna just I have a lot to say in response to your question, Mike. I'm gonna log off and start over.
All right.
We'll be here.
We'll be here. I mean, he is really one of the
How about
architects and experts.
Can you hear me now?
Yes.
Yeah.
The echo, great. There are large distinctions between the work that we do and the work that rapid diversion does. Our population is almost exclusively felons. And we have the option, because we have both the ODR housing program, which is a post-plea probationary program, and diversion. When we launched the program, we had no protocols. Anything could be referred in, and we would accept people as long as their case could be reduced to something in which probation could be granted. So a lot of serious cases went under probation supervision and people were released to us. And then with the advent of the diversion statutes, what we had was a system where cases would be referred in and considered for diversion first. And if they weren't eligible for diversion or there couldn't be an agreement reached on diversion, we would take a plea and place them in ODR housing.
Can I just understand? Diversion, I feel like, is one of these words that is an umbrella term that covers a lot of stuff that isn't precise. So Stephanie, you were talking about a pre-trial, pre-plea program. I'm trying to avoid the D word. And then Judge Espinoza, ODR
Does both.
is both. Okay.
Both.
So it could take people either pre-plea or after their plea, so long as they are placed on probation as a result. Is that what you're saying?
No, if it's straight diversion, there's no probation.
And what do you mean by straight diversion? Can I just...
The same diversion statute that's used by rapid diversion.
So, and this is pre-plea. People are referred to ODR by the judge or by the court?
Our case works through attorney referral.
Okay.
So Defense bar refers a case to us. They're clinically assessed. We have psychiatrists embedded in the jail and in court, psychiatrists, and then other sorts of forensic mental health folks. Um, if we feel that we can safely care for someone in the community, and we do provide, and Stephanie pointed this out, everyone that comes to us goes into one of our housing sites. So we have interim and then permanent supportive housing for our population. And our commitment to this population is permanent supportive housing for life, as long as they are not recidivating. And our recidivism rates are incredibly low, as I indicated previously. We have other programs. We have a FIST program for incompetent felons who are incompetent to stand trial. We have a maternal health program for pregnant women in the jail. But in terms of straight diversion, our population is almost exclusive. In fact, it is exclusively felons for diversion.
It, just in terms of the patchwork issue that I was mentioning before, I mean, we're also just talking in Los Angeles, and I say just because Los Angeles is giant, but um, in your opinion, is it does seem to me from the outsider like there's these patchworks that kind of overlap in some ways and some and don't, and these are just two examples. Is that correct? Is that okay in terms of the way that you think that it should be progress, or would it make sense to you to have kind of like one organization, one institution that kind of brought everything together?
I have to be honest, Mike, that's a political question I'd rather not wade into.
Okay.
A lot of sort of history behind why there are patchwork approaches. I will say that the rapid diversion program is limited in terms of the acuity of the participants. We tend to we tend to be diverting or housing folks who are incredibly sick. They're called what are called P3, P4 patients in the jail, which means they've been characterized as needing a high level of care. And again, we take over their medication while they're still in custody because we have psychiatrists embedded in the jail. And we get them ready for release where it's the other program, the rapid diversion program, is able to deal with people who are less acute. I think it might be better if it were all under one umbrella, but that's a larger political question and keep in mind, I've been away from the county now for almost 4 years.
And
And
then my
I
last,
will,
go ahead,
sorry,
go
I
ahead,
was just
Stephanie.
going to say, yeah, setting aside the oversight question and the political piece of things, we asked in our interviews of folks how they conceptualize the distinction between ODR, between RDP, between just like traditional diversion where you would retain your own expert and put together a treatment plan. And folks really do see this as a continuum of options where there's something appropriate for each type of client. And so yes, there is benefit, I guess, is what I'm saying, to having these different types of options.
And Stephanie, if I'm recalling your slide correctly, the RDP program has about maybe 1,000 people a year. Was that sounded like?
That sounds roughly right, at least during the period we were looking at.
And Judge Espinoza, do you know about the number of people per year that go into ODR?
Well, I'll just say in 10 years, we've removed over 15,000
So,
persons from the jail. I went to law school because I was promised there'd be no math.
right.
So
Well, I'll tell you, it's roughly the same, 1,500, we'll say if that's the average, but
sounds low. We have currently
a year.
3,000 people in our housing, but I'm going to rely on your math, Mike. That sounds right. Sounds right.
All right, this is super helpful. Any other questions from the committee? All right, I think this is actually a good segue to talking about further diversions. So now that we've heard about the prison programs and problems there, and perhaps a potential solution from Los Angeles, our staff will now give us a little bit more legal background on the diversion and present some staff recommendations on the topic. They'll also give us some background and recommendations on other major topics for the day, including record relief. Along with the staff presentation, we'll also hear from Melissa Skog from California Policy Lab about automatic record relief in California and how people may be affected. So, Tom, you want to take it away?
Great. So we'll get some more background, build on what we've heard already, and then end with some recommendations on diversion. Then we'll kind of transition over to record relief. And please interrupt me with questions, comments, other exclamations as we go. We're hoping to sort of have the discussion of the topic as we go.
Right. I want to emphasize that. Whereas we're our guests, we try to give them 5 minutes uninterrupted and then have Q&A. Otherwise, this is with our experimental process here is that we really want to try to have a discussion among the committee members and staff as we move into this segment of our broadcast.
All right, let's get going. So, just again to set the stage a little bit, diversion is a process that allows someone to avoid a criminal conviction by fulfilling conditions set by a court and your case is dismissed. And then what happens after that is actually something we'll talk about a little bit later about record sealing and things like that. But that's the idea. Is you don't have to plead guilty, and the judge, sets conditions, and those conditions can range depending upon what the type of diversion is. And we'll talk about that a little bit too. But this isn't sort of the case goes away, no one ever checks on you, get out of jail free card. Like I think diversion is sometimes understood in some of the discussions that are had about these programs.
And is it automatically result in dismissal, or can it be a reduction in charges, or is it not diversion if it's a reduction? Can you just is that like the definition of diversion, that it has to be a dismissal?
I think so, that you don't end up with a criminal conviction of any kind. Right, but that's an interesting twist on it too. And there's been a lot of, I would say, recent research on programs that are not in California, and everything I'm saying here, all the citations, everything are in the memo. So for folks who are watching, this is not just us saying it; it's all backed up by research and everything. But the research shows that folks who get diversion, especially in lower level cases, tend to have much lower recidivism than people who don't, and it also increases employment and the amount of money you earn over time. Some of the research also shows that for real low level cases like misdemeanors, the conditions can be pretty non-intensive, like meeting with a case manager once or twice, and that can even lead to some of these benefits. Now, of course, every program is different, every state is different, so we'll come back to that a little bit in one of the staff recommendations about trying to do some of that here in California. But generally, the research on diversion shows that it improves public safety and has these other positive outcomes as well. And now we're going to talk about three of the most utilized programs in California. That's court-initiated misdemeanor diversion, mental health diversion, which is what we spent all morning talking about so far, and military diversion. There are other programs, but these are the ones we think are worth focusing on. All right, so let's start with the misdemeanor diversion. So this is a relatively recent innovation. Actually, for folks who have been with the Penal Code Committee a long time, we actually heard a presentation from Judge Lowenthal at our first real meeting in March 2020. Or April 20. It was supposed to be in March, and then we had to change it for reasons everyone will understand, about expanding this program. And that happened from a bill that year. So it's been in effect about 5 years. And what it does is it allows a court to say, I'm going to give this person diversion. I'll set the conditions. They can last for up to 2 years. And if you complete, as we talked about, the case is dismissed. It doesn't require the prosecution's consent. It can be done over the objections. It's really up to the judge. And, I think a lot of us are familiar with this, but misdemeanor is by far the most common criminal filing in criminal court. Depending upon how you count it, it's about 70% of criminal filings. But many of those are DUIs, which are not eligible for misdemeanor diversion. And as you all probably remember, when we looked at DUI a few years ago, one of the recommendations the committee made was let there be diversion for DUI. Other things that are not eligible are stalking, domestic violence, and any sex offenses. And while you're on diversion, you still have to pay restitution if you can. And so their victims' rights are honored during the process, a lot of them. But one thing that doesn't happen is if your case is dismissed and if you had been convicted, you would have had points on your license. You don't get those points on your license. And that's something that, maybe we should think about as a recommendation, and we'll come back to that. So that's court-initiated misdemeanor diversion. It's been around about 5 years, applies to many of the cases coming into court, and the judge has total discretion about what to set for it. Mike.
Tom, do we know about the volume of people who go through this, Mr. Uniform?
No.
Okay.
I wish I had a more complex answer, but no.
Well,
I mean,
straightforward one.
Yeah, I mean, in our research and sort of preparing for the meeting, Joy and I talked to, a lot of people, and I think it's a pretty common thing. It wasn't like some bizarre thing that only happened in extreme cases, but there isn't real numbers on it. Okay. So that takes us back to mental health diversion. So I just want to get a little more legal background. I think what we heard from Stephanie's presentation is that there's a pretty intense evaluation process that happens in the RDP program, and that you can sort of see that reflected in the statute a little bit. There are basically 7 things the court has to go through before it can even reach the question of whether it wants to grant diversion. I'll go through them very quickly. And they're sort of divided into whether you're eligible and whether then you're suitable for diversion. I don't think we need to really worry about that distinction. But the first is, do you have a diagnosed mental disorder within the last 5 years? Almost everything in the DSM-5 is eligible, with a few exceptions. And the second thing is, there has to be a connection between the disorder and the offense. And this is now presumed, and that's thanks to a bill that was based on a recommendation from the Penal Code Committee a few years ago. So there's a presumed connection unless proven otherwise by clear and convincing evidence. And this does seem to have had the effect I think the committee was hoping for, of increasing the amount of people getting diversion. And there's some other things the court has to consider: whether the symptoms that contributed to the criminal behavior would respond to treatment. Pretty common sense. The defendant has to consent to diversion and agree to comply with treatment. And the final thing, this is, I think, what has become the most of a hot topic around mental health diversion, is the court has to conclude that you're not an unreasonable risk of danger to public safety, which means you don't have a risk of committing a super strike, which is that list of offenses of sort of the most serious offenses, murder and similar things like that in the penal code. So even if the defendant satisfies all 7 of those criteria, the court still retains what the appellate courts are calling residual discretion on whether to grant diversion or not. So it could still deny. The case law, the most recent case on it said that the law here was growing and developing, which I guess is legalese for, I don't know, you can sort of figure out what that means. I think there's a little uncertainty in that. And as you all also discussed already, there's a few bills pending this year, and there were last year, that would modify the diversion requirements. I think the understanding by everyone, depending upon where you are on the issue, is it would make it harder for judges to grant diversion. There would be less diversion. And the main way it would do it is it would modify that public safety standard. And instead of risk of committing a super strike, it'd be a risk of substantial and undue risk of just physical safety of another person. We usually don't prognosticate on the fate of bills, but this, I think, it would be safe to say this bill has a lot of support behind it in the legislature right now, and it seems pretty likely it will pass into law in some form. There's some other bills pending as well, but that is sort of the most prominent. The other legal background I think it's worth having here is, when can you ask for diversion? So we heard about this rapid diversion program that happens soon after arrest, once the case begins. Well, the California Supreme Court has said you can ask for diversion based on the way the statute is written up until your trial begins, basically. And that was a case in 2023, and Justices Kelly Evans and Goodwin Liu dissented and said, well, you should be able to ask for diversion until the case is over, basically until sentencing, because there are going to be these rare scenarios where that makes the most sense. And in fact, in that case, the person had been diagnosed with schizophrenia. The offense was assaulting a family member and then assaulting a police officer who responded, represented himself at trial, was convicted, and then was appointed counsel after conviction. And immediately the defense attorney says, well, we have to have mental health diversion considered here. And the courts say, you can't do that. So, we'll come back to that as a recommendation. That's sort of the state of the law right now. A little more data on how often mental health diversion is happening. We're in a better position than we are with the misdemeanor diversion. So the Judicial Council reports regularly on this. They try to get data from every county, but in the most recent report, Los Angeles County and San Diego and some other big counties just didn't have anything in the report. But in what is reported, some counties report granting 0 petitions. These tend to be smaller counties, but literally 0 petitions are granted, according to this the data they report in the Judicial Council. Of the counties that do report granting some petitions, it's a similar mix to what we saw from the rapid diversion program. It's about 57% felony cases, 43% misdemeanor cases. So not quite split evenly, but pretty close. And this is not something that's only limited to misdemeanor cases, which I think is a good takeaway from that. And then, and the 10 largest counties that are reporting full data for the most recent year, where we can compare the number of felony cases that are filed in the county and the amount of diversion petitions that are granted, there's about 171 petitions granted out of an average of around almost 8,000 felony cases filed. So it's not a huge percent of the felony caseload. And we have some county specific looks at that here. So this is looking at the county level of felony filings in in the most recent fiscal year we can do this for, which is 2023, 2024, compared to the number of granted petitions and felony cases. What percentage of the felony filings are covered by that? And we see pretty big county variation. So Sacramento, it's 6% of cases, which is more than double the next county in Fresno, which is 3%. And we go down, Alameda is about 1.5%. And Orange County 1%. So we see pretty big variation. And I actually think that kind of relates to the bill I mentioned before, AB 46, which seems to be very much driven by folks in the Sacramento area. So it seems like the courts in Sacramento, I don't know if it's the courts or whatever, there's a lot more mental health diversion apparently happening in Sacramento than in other counties. Of course, we don't have LA and some other big counties.
But I mean, I do want to note that and I know that this is a kind of a rough math in terms of how many people are really going through it, but 6% is still really low number considering that 40% of the people in prison have mental health issues and about the same, at least as much in jails statewide. So it seems like this is a small fraction of people who, should be considered at least.
I think that's a fair takeaway. And this is just folks who are granted diversion. It's not about who finishes. So it's going to be even lower than that for folks who totally avoid.
Or who's even apply, right? It doesn't even talk about.
Exactly. Right. Though some of the rhetoric around the current program is that if you apply, you are essentially guaranteed to be granted because of the way the statute is set up. Again, I think this also helps rebut that because we're seeing very different,
Right, exactly. If that were the case, then everybody would get it and we'd have much higher numbers of people. I mean, right, if everybody automatically got it, then public defenders would be asking for it all the time and getting it all the time, which appears that they're not.
We don't want to draw too many conclusions from this, but I think this is the data that's available from the Judicial Council. So I think it's helpful just to put things in context for sure. Okay, and then what about outcomes? So again, this is just building upon what we heard earlier about the rapid diversion program, that the folks who graduated had very low rate of filing new cases. It's hard to compare that to anything else, but if we do look at folks who are released from CDCR who are in the sort of one of the more intense mental health treatment programs, the EEOP program, 48% of those folks are reconvicted of a new offense within 3 years. So it's definitely not an apples to apples comparison. But again, I think the disparity is so big that it's still a helpful one to make. All right, so that's mental health diversion. Let's talk about military diversion briefly. So this is a program available to people who are suffering from sexual trauma, traumatic brain injury, PTSD, substance abuse, or other mental health problems as a result of their military service. Both misdemeanors and felonies are eligible. And unlike the other programs we talked about, DUIs are eligible for military diversion. And for misdemeanors, you don't have to show a connection between the sort of mental health problem and the offense. It's just if you have the mental health problem as a result of your military service and you're charged with a misdemeanor, you're eligible. For felonies, you do have to show that connection, but it literally copied the language from the mental health diversion statute and said there's a presumption that there's a connection.
The military, I know that there's a military provision. Is it the same one that applies retroactively for resentencing? Is this the same?
It's different statutes, and this is a pretrial diversion, and there is a resentencing for veterans as well. So it's the same idea, but it's different statutory schemes. Okay. And the other difference in the statute between misdemeanors and felonies, this is a very small technical thing, but I think it's the kind of thing that's good for us to, say should be fixed, is for a felony case, the statute's very specific about what kind of evidence a court can consider. The misdemeanor statute is silent on that, and there's an appellate court that recently said this probably means a court has a little more discretion about what to consider in the felony context, so it might be easier to make a case for felony diversion than it is for misdemeanor diversion, which seems a little backwards. So it'd be an easy fix to make, but it needs to be fixed. Okay, so that's the overview of the legal background for the diversion programs and what data we have, which varies on the program. And we have 5 staff recommendations that we think are the committee worth making. The first, and I think the most significant one, and I'm glad Assemblymember Hawari is still here because she has a bill that would do this. That's consistent with other things the committee has said over the years, but it would be expand that misdemeanor-led judicial program to lower level felonies and sort of just do what seems to be working well in that program to more felonies. And as we saw with other diversion programs, it's appropriate and seems to be working for felonies as well. So that's the first staff proposal. The second is to fix that little statutory inconsistency that I just mentioned for the misdemeanor military diversion to specify that whatever you can consider in felony case, you consider in the misdemeanor case. Again, a small fix, but one that would help ease the path for folks who are eligible for that. The third has to do with mental health diversion. It's to clarify that requests for mental health diversion can be made until sentencing. So this would basically take the point of view that Justices Evans and Liu had in that case that I mentioned. And I think it would not come up that often, because if you're going to apply for diversion, you want to do that as quickly as possible. It's in your best interest and your client's best interest if you're the attorney. And second, so few cases go to trial that, it's necessarily a small universe. Professor Ochin, I saw you have your hand up.
Yeah, I have a sort of a technical legal question about appellate review of grants of diversion, mental health diversion. And it seems like in the memo there have been the appellate courts have been active in reviewing when mental health diversion is offered, and obviously the prosecution appeals. Um, and I'm just wondering, what's the standard of review for
Oh
courts
boy.
considering, questions around whether mental health diversion was appropriately granted?
It would depend on exactly whether you're saying, well, the court made a mistake in finding that I wasn't eligible or the person was eligible, or whether they're sort of exercising that residual discretion. But you're absolutely right. I think when appellate courts are presented with these cases, they can really spend a lot of time with them. But other courts are not doing that and are being very quick to say, well, this person obviously isn't eligible because they have prior burglary convictions. So that's their risk of committing a super strike. So I think it sort of depends on what the division you're in a little bit,
Mhm.
unfortunately. And there isn't a California Supreme Court case on the sort of that discretionary issue and how a court should consider these cases on the merits. They've only engaged on these sort of much more procedural things about timing and retroactivity. But so I think the standard
So
of review
is it
is
like abuse of discretion standard?
yes, but it's abuse of residual discretion. So the court doesn't have full discretion, and it's not sort of abuse of discretion tends to be, I don't know, almost anything goes to put it
Right.
in colloquial terms. Abuse of residual discretion is a little more, well, it has to still be consistent with the statute, and I think what that means. A lot of the judges we spoke with said it would be great to get more guidance on that.
Is this something where we can make recommendations to the legislature to guide, the scope of review for courts on appeal, what they should be considering, if it's, an abuse of discretion standard? Abuse of discretion is, should weigh these factors, or clear and convincing, I don't know if clear and convincing evidence is appropriate, but something
Right.
that gives some more guidance in terms of, so we don't see these, what we shouldn't see is huge disparities in terms of, courts in this division are doing X and courts in this division are doing Y, because again, that's appellate courts should be, I think, ensuring uniformity across the state. And so if you have these wildly different standards of review, right? One person in LA County has their, diversion upheld, another person in a different county gets it overturned, but for very different reasons. And that seems wrong.
Yes, I suspect, you know, making this process more complex is something I think most judges would have a negative reaction to based on the discussions we've had. In my but it's something we can definitely consider because you already have these sort of seven factors, this residual discretion, and then these built-in standards of review. Is there substantial evidence for the things there has to be evidence, and then abuse of residual discretion. So there's a lot of, I'd say there's almost too much guidance as is, and I
Mm.
wonder if
I mean, if it
adding
can we
more,
simplify? I mean, I would view this as
right?
simplifying it, not making it more complicated. But the idea would be that we would have clear expectations in terms of how judges are applying these standards and ensuring that they're more uniform. To the extent that we can. You're right. I mean, judges are able to frame language in the ways that they want. But I think that I'd be interested in getting the staff's view on that.
Yeah. Okay. Well, we'll work on that. I think the direction the legislature is going right now is sort of the opposite to open up the for there to be a little less direction from the legislature in a way about granting diversion in more cases. But we'll take a look at that. Assembly Member El Hawari.
I have, it might be really loud in my background, so please let me know if you can't hear me.
No, you're good.
I'm not sure if this is a question for this space, but I wanted to just flag. I know that you all mentioned that this is kind of moving in the legislature, this particular kind of anti-diversion bill. And I was wondering if there is an opportunity to really think through like how to ensure that that's not moving forward. Because I think it's an important piece. I think as you are like what we need, the option, and I think it's like uh, it maybe has more momentum. So just really thinking about like what are the pieces that we could um, kind of discuss that could really help move folks to understand that this is actually going in the wrong direction. I have a couple other questions, but I'll just focus on this one for now. If this is a possible question to talk about.
Can I just ask a question? Like, I mean, hearing the data uh, from from Stephanie Holliday and reading the memo, 91% uh, success. What is the problem that the legislature is trying to solve? Like with these,
So
like
yeah, that's a
I,
good
I
question.
I'm unclear what the problem is.
Yeah, it's these like one story kind of like utilizing this um like one bad story as a way to then tell the entire kind of like paint the entire picture. Someone got out on diversion and then they committed a murder.
But it's the opposite. But like if you don't have diversion, 70 to 80% of people get out and
Sorry about the
will
background noise.
definitely
When
commit a
ninety-one
crime.
percent
It's so
is
strange.
the right, and I think that when we recognize the 91%, I think folks are instead ignoring that and kind of looking at like these big media headlines instead. And so I think last year the only bill that I stood up to speak out against was this bill, and it's like I, like what what you're saying I think is important. Also, I think what folks are hearing in their communities is also something that they're um you know and so bringing
Yeah,
you all generally
we're catching every third
I'm
word.
so sorry.
Yeah, we're not catching everything you're saying.
I'm so
So let me just weigh in here
okay.
while we hopefully
I
get
can stop it if that's
clear
helpful.
signal.
Okay.
And yeah, some
Um,
member where I think you could turn off your video because we're obviously having technical issues, and maybe
Quality.
we'll be able to hear you better.
Can you hear me better now?
Not
No,
really.
worth a try.
Um, Professor Ocha, my feeling about these media stories that we're just hearing about, they're really, really amplified in light of the governor's presidential aspirations. And I just think that people are really trying to go after him, and in turn, the governor's office is being really especially cautious in the past 12 months or so. That's at least my take on things. So I'm a little bit optimistic for the future, actually. But that's my take. I'm curious about um, what other people think, but that's generally my take. And I agree with you that this can and should be simplified, but just in terms of the political momentum, I think yep, Assembly member.
You're on mute if you're speaking, Assembly member.
Heidi, you want to jump in?
It's a very quick point. I mean, to your point and to Tom's point, and I think it's important for us to be aware of the political climate, but it's also important for us to make the recommendations we think are the best policy for California. And we can do that. We can make a robust recommendation for what we really think makes sense for California. And we can have an alternative or something that acknowledges the political climate or is realistic. But that's the way that's the direction I would suggest.
Yeah, I agree. I'm actually optimistic about the political climate, actually. And our recommendations, of course, the things that we consider for this year will be recommendations for the next legislative cycle, which will have a new administration, which I suspect will be more favorable, or that the media climate will be less intense.
Um, one thing I'd add to the discussion is one of the appellate cases that reversed the denial of mental health diversion, the defendant had been granted probation and had been out in the community. And so it just seemed to be a desire from the prosecutor and perhaps the court that the person just had a conviction. It wasn't about they should necessarily be locked up or even receiving any kind of treatment. It just seemed to be that seemed to be the most important thing. So I think part of the discussion around mental health diversion, the legislature is like, well, is about accountability. Like, unless you're getting a conviction, the system, you're just getting off free. So that's I think part of it is people hear diversion and they assume it's you sort of get a coloring book and you return it to the court a week later and then your case is dismissed. That's obviously not what's happening, but some of the rhetoric is pretty close to that. So I think one reason we wanted to spend a lot of time on this topic was today to at least have a record a little bit of what data is there and available and what seems to be working or not working.
Yeah, well, I mean, look, if they're coloring books, I'm in. So let me know. So one question I have is about something that Ms. Holliday raised, which is about misdemeanants who are maybe hesitant to seek diversion because of the length of time, right? So a misdemeanor conviction, if you serve the time, would be far less, and then you're done, potentially you're done, versus being under supervision for 2 years and potentially having things revoked and having the uncertainty around it. And I'm wondering if there's anything that we can do to try, presuming that we still have diversion, robust diversion programs going forward, how we can encourage people to opt into them. I've talked to people who have been on like probationary type of programs where they can divert out, and the sense is I'm staying on the hook longer than I need to, and having the state involved in my life very deeply about where I can live, who I can see, all of these things that, infringe on my ability to make choices as an adult for a very long period of time, versus I spend 3 months in jail and then I'm out. Um, I'm wondering, what to make of that, and if there's anything that we can do as a committee to really address those very real concerns that people have in terms of the net widening effect of diversionary programs and putting people under supervision for longer than they would be if they pled guilty and served time in a jail facility, which has implications for our jail populations and the size of the jail population. So I'm just wondering, what to make of those concerns.
I had very similar questions. Tom, do you know anything? Can you talk to that at all?
Well, I think a lot of people don't pursue diversion or even probation sometimes for all those reasons. Like, I can do a week in jail and be done and not have to deal with that. So I think it's an issue throughout the system in a way. And I have no idea how to think of a more global solution, because I think it's very dependent on the person and their counsel to walk through all that. And you just, when I was a practitioner, remember many conversations of working through those issues, and it's very complicated because there's often the opposite side too, where people think they're going to do great in a program, and you just know they're not ready for it yet, and they end up doing longer than they would have from trying. So it's I don't have a great answer, but we can think about it. Okay, well,
To that point, it seems like I was just going to add that it seems like what Judge Espinosa mentioned about Rand and having people in the courtroom, there, the
right.
case management, it really benefits the people, at the ground level and shows them that they can have access to it. I don't know how to legislate that, but that seems like it could make a huge difference.
To get back to the recommendations, I think the next one I was going to cover, which is number 3 here, is actually related to a lot of these issues. Which I'm sorry, it's number 4. So number 3 was allow more time to request. The study that we heard about this morning is the only study that we could find of mental health diversion in California, and it's a helpful study, but it's just that one program, NLA, and it's great that we have it, but how applicable is it to other places? So we would recommend, and we usually don't like to recommend there should be a study of a program, because we like to do those studies when we can. But the situation is unique here in that all the data about who requests diversion, who's granted it, who succeeds, that is not kept very well statewide by the Department of Justice or anyone else. So that's all going to be local data, and that it would require a lot of coordination with courts and others at the local level to actually get that and study it, and then to look at recidivism and other outcomes at the more state level. So perhaps if there was a study that wasn't limited to one program in LA, we could help rebut some of the more anecdote-driven responses to these programs. And it might also point out there are areas that should change, that, certain folks are at a much higher risk of being public safety risk than others on these programs. So I think we just need to be very deliberate about getting that data and doing it. And committee can't do it itself. I think this is something the legislature and the governor would have to get behind, as they have when studying other programs. Judge Espinoza.
Yeah, at the risk of doing exactly what you don't want to do, which is spend more time focused on a single program, I would encourage the staff to reach out to the leadership of the Office of Diversion and Reentry to get a more granular analysis of our felony diversion and felony post-plea programs. We're dealing with very serious cases and very sick folks, and our outcomes are incredibly strong. I've been away from the program for almost 4 years, so what I'm giving you is secondhand based on my conversations with them. But I think if you just spent an hour talking to the leadership of that program, you'd get a better sense of what it's like to both divert or remove people on probation from the jail, serious mental illness.
We'll do it. Will you join us, or are you not interested?
Oh, I'm very.
Okay.
This is my passion at the moment. So yes.
All right. I'll follow up with you about that. And the last one, major change in topic, but we can do it. This has to do with misdemeanor diversion for vehicular manslaughter. So vehicular manslaughter, when you cause a car accident without gross negligence that someone dies as a result of, it's a misdemeanor offense, and you can get misdemeanor diversion for it. Now, you can't get it for just driving drunk, but you can get it for vehicular manslaughter. So there's, one of the reasons we recommended you should be able to get diversion for DUI. But if you get successful diversion for this, you don't get points on your license, and it just seems reasonable that you did cause this accident to get the license points, which again, on their own, don't do that much. You'd have to get more points in a certain amount of time before there were restrictions on your license. So it'd be a way to sort of, better align some of the consequences of diversion than they are right now, in our opinion. And there are 2 bills, not just one, but 2 bills pending right now that would do this. So events will probably overtake this as a final committee recommendation, but in the event that doesn't happen, it seems appropriate for us to wait in here.
So Tom,
Okay, so
I think
yeah.
these, oh, sorry, my stuff. Anyway.
No, I was going to say that's it.
Okay, good. Before we move on, just quickly, is that I think these make a lot of sense. They're modest. In addition, I would like to say that, as we said earlier, I think that Professor Ochen first suggested is like as much additional data as we can about what's going on in the prison population and jail populations in terms of who's there for what, racial breakdowns, how long. If we can, to the extent that that's gettable, I think that we're all very curious about that.
It's a lot harder with jail than it is with prison, but we'll take a look. I mean, most people who are in jail are there for a day or two. I mean, that's the reality. It's there's a lot of churn in jail, and there are folks who stay longer. And I think that's obviously what we're more interested in. All right, so we will work these up, and the other discussion that we had too, we'll as we do, we'll report back. Our next meeting is in May, so it's in about a month. So we may not have made a lot of progress on all these, but we'll continue to do it. Okay, now let's. Should we take a break, Mike, or keep going? I think the next portion of our discussion will move quicker, but maybe it's a good idea to take a break. What do you
Okay,
think?
yeah, let's take a 5-minute break. Let's get back here at I guess a 7-minute break, 11:10. Let's be prompt so we can keep it moving promptly. But 11:10, see you back here.